You've done this before.
I have, Mr. Chairman, and this is the part of the job I do not miss.
Yeah.
So, Craig Eiland, I'm here, although I'm a registered lobbyist, I'm here today to testify on my own behalf. And I have, what I have is for the, to go through the bill on specific items of concern.
You're against the bill, right?
Yes, sir, I'm against the bill
Okay.
In its present form.
Okay. Yeah, we'll get those passed out. Go ahead.
Okay. So if you turn to page 6, it talks about the inspection report, and the portion that I have, the first concern is that it's the before bringing an action, asserting a claim, the governmental entity, and I note this does not just apply to school districts.
What line are you on?
I'm sorry, it is, I got a non-legal version. It's the 2272.003 inspection report.
Okay.
It said the very first word is before bringing an action.
Yeah.
The first thing it says you've got the governmental entity must retain employment of an independent third-party licensed professional engineer. And so first, I think that y'all talked about that, but that conflicts with Civil Practice and Remedies Code, Chapter 15.001. 2. And so we've got to fix that because an engineer can't give an opinion against an architect, and like the lady said, we don't want to require somebody that's not going to be able to use that opinion later in court.
Sure.
So that needs to be addressed. The other thing is that the way I read the bill, when you move down to B, the governmental entity must provide written notice of an inspection required by this section to each party who is the subject of the claim, not later than the 10th day before the date of the inspection will occur. So I think we're backwards here, because even before the city or the county or the MUD or the school district goes out for the very first time to do an inspection to see what is the construction defect, what is the extent of it, we're saying before you ever do that, you've got to put everybody on notice 10 days before the inspection, so that you've got to give notice to the the basketball bleachers lady,
Yeah.
even though you're not claiming it, and you got to give notice to the plumber, even though you're complaining about an HVAC issue. And so what I think this section has to be reworked, that after you do an inspection, if you're going to bring a claim, you've got to provide a report, and you've got to give the general contractor and subs an opportunity to come inspect before you can ever file a lawsuit. Kind of like we did, or like y'all did last session on the Hale bill, but this, I think, is going to be a waste of time if before I ever know that I've got a valid claim and a certificate of merit, that I have to give everybody notice. So that's my
the goal
concern.
there, Craig, is just to have everybody have the ability to attend to the inspection,
Right.
to get the minds in the room and look at it together and try to come up with a workable solution. That's the intent, at least, but we
Right.
can work on the language.
Yeah, I think you would want the city or the school district to actually do that inspection so they know what the claim is before they tell everybody to come out and take a look. So that's the first issue there. And as far as the engineer, we want to make sure that it's the trades that are involved, whether it's HVAC, an electrician, a plumber, as opposed to just an engineer. And also, I note that a lot of times, at least in my experience, a construction defect is identified by an insurance company as part of an insurance claim. They'll come back and say, "Well, your claim is not an insurance claim; it's a construction defect claim." And if you're required to do all this, that wouldn't work with the way the bill is currently drafted as far as the structure. Once again, over on B1, you have to identify the engineer who will conduct the inspection ahead of time. We got to fix, that conflicts with 150.02. Then down below, where you're trying to make sure everybody has an opportunity to inspect, this could lead to a real games plan, because if oftentimes, as you've said, the owner or the city, the county, the MUD may not know who the subs are, so the entity will give notice to the general contractor. The general contractor can then stagger out notices to the subs, because it says when the party subject to the claim has at least 150 days after the report to provide to inspect or correct. And so I think the goal is correct, but as you just noted a while ago, when does the duty of the school or the city end of giving notice to the general contractor, and then the general contractor give notice to the subs?
Yeah.
Because we don't want any game playing and delays there. And then it's been talked about the opportunity to correct the defect. If you've lost, maybe we should give them an opportunity to come up with a plan of how to correct it and a price that they would do it for, that it should cost, and the offer to correct. But I don't think that we want to require a school district to retain the same people that caused the defect in the first place. Maybe they can work it out, but I don't think the legislation should require it. I know if I was a homeowner, even under RECLA, I'm not required to hire the same home builder who caused the defect in the first place to repair it. I got to give them a chance to come inspect it. I got to give them a chance to make an offer. But even if I accept the offer or allow them to correct it, I don't have to let that home builder fix it themselves.
But in this situation, that opportunity to inspect and repair is just a condition precedent to filing suit. You could be done, wash your hands of the contractor, have nothing to do with them, go hire another contractor to fix the problem. But if you're going to pursue the original contractor who did the work in a lawsuit, you've got to give them the opportunity. You would disagree with that?
I would disagree that I have to let that person correct it. I can let them come up with a plan. I can let them make an offer. But for me to require me statutorily to allow the same person who caused the defect to correct the defect, I just don't think that's right. And I think that entity should be given the opportunity to inspect, to come up with a plan to correct it perhaps, come up with an offer to settle, but not require a city council, the county commissioners, or a school board to be forced to hire that exact same entity that caused the defect. I just don't think that should be in here. But I certainly think they ought to have a chance to inspect it and to come up with a plan to correct it. Over on 2272.07, recovery of the inspection cost. If the public entity is successful, I think that the may, on the third last bottom, the party responsible for the construction defect may include amounts paid by the government entity to obtain an inspection report. I think that should be shall, because otherwise it's kind of like an unfunded mandate. We are requiring them to do this, but we are not guaranteeing that they will recover the cost of the inspection if they are successful. So I think that would be a kind of an unfunded mandate. And then the last one, over on the insurance treatment of a claim, 2272.09. I'm not sure. I haven't studied this insurance provision because it says if a party in connection with the potential claim receives a written notice of the alleged construction defect, identifying the construction defect, and provides a notice or report to the party's insurer, the insurer shall treat the provision of the notice or report as the filing of a lawsuit asserting a claim. So I think there's other ramifications that we may want to consider. I mean, I'm assuming that this is in there because they want to be able to get their inspection fees and expenses, but there may be other issues under general liability policy that need to be fleshed out before it's put in statute, because maybe we just let them handle it under the policy as it exists as opposed to trying to change their policy statutorily.
Okay.
But otherwise, I think it's a great bill.
In its current form.
Members, any questions? Craig, I appreciate it. Thank
Yes, sir.
you for sticking with us
I'm
tonight.
here to help in any way I can.
Yeah, thank you.